And welcome back to Law and Crime. We hope you enjoyed that episode of BS with Bill Stanton. I'm joined right now with Law and Crime's very own Aaron Keller. Aaron, welcome to the show.
Caroline, good to see you. I haven't seen you in a while.
I know, I miss you.
I miss you too, but I work from home today, and you're sitting in what sometimes is my chair.
It is. I do think of it as your chair. Well, I'm happy that it fit into your schedule to come talk about these really great 2 articles that you have up now on lawandcrime.com. Again, today we're doing many special segments for our viewers, and this is one of them. We want to talk about this. The first piece that you wrote, Aaron, is entitled, I love this, Trump judicial pick completely stammers through really easy legal questions. You guys, this video went viral. It's a video of Republican Senator John Kennedy of Louisiana just reaming a panel of Trump's judicial picks in a Senate Judiciary Committee hearing. Again, it's gone viral. Law and Crime's own very own Aaron Keller has done some pretty great analysis about it. Aaron, talk to me about this issue.
Okay, so it's one of these things where I wake up in the morning, I take a look at the news like I do every morning, and this video, which got posted and shared last evening, it's just a standard Senate Judiciary Committee video, had about 1.75 million views when I woke up this morning, and I think now it's over 3 million. So this thing is getting millions of views adding up by the hour. And look, these are loyal Republicans hammering a Republican president's own judicial picks. I don't remember that happening very frequently in my lifetime, but there have been some serious questions about whether or not President Trump's picks are being picked for ideological or political reasons, or whether they're being picked for legal ability. And this video, about 5 minutes long, just seems to be crystallizing that debate in one snip.
Yeah, so interesting that it's actually a Republican senator that's doing the questioning. Some tough questions on nominee Matthew Spencer Peterson, whom President Trump nominated to a federal judgeship in D.C. specifically. I think we have that clip on the lawandcrime.com website. So to all our viewers, make sure to check it out there. He currently... And Aaron, tell us about sort of the questioning, the line of questioning, because it's hysterical. You also have a transcript of the questions in your article. Take us through that line of questioning and sort of what it highlights about Trump's nominees.
Well, forgive me if I'm wrong, but I think we actually do have the clip, so I'm hoping that we can actually play it here on the network. Maybe the guys can let you know if we have it. But look,
yeah, let's see if we can play it.
These are really basic questions that the senator was asking. Look, have you been involved in litigating a case? Civil trial, criminal trial? Have you tried a case through to a verdict? Have you ever been involved in taking a deposition? And these are things that lawyers who practice for about a year should be doing.
Right.
And the answers were all too often, no, I have not. Well, I was involved in a deposition, but I didn't do it myself. I had help or someone else there. And of course, once you heard that, it wasn't a surprise that things were going to degenerate and go downhill from there.
Yeah, he tried to deflect at one point, right? He tried to deflect kind of, after the question, have you ever tried a case to verdict? No. Have you ever done a trial at all? No. Civil, criminal? No. Federal, state? No. The deposition I loved, when he tried to say he maybe had participated in a deposition, in his work at a law firm, and was it fewer than 10? Absolutely. Was it fewer than 5? Maybe.
Yeah. It went on and on. So look, then of course you get into some substantive law things. And look, these are not obscure cases that nobody knows about. These are not cases that nobody studies. These are like the big cases that as a law student are going to absolutely be on not only your professor's exam, but the bar exam. I mean, they're just the cases everybody has to know. And the candidates are sitting there saying, no, I don't know anything about those. I don't know anything about what a motion in limine is.
Yeah, that was the most offensive. The Daubert standard, well, we can let that one slide maybe. I mean, tell us what the Daubert standard is.
Well, okay, so a lot of people who watched Making a Murderer got an education in this from me because I talked about it extensively right after the film came out. The Daubert standard was one of the senator's questions, and it's an evidence standard that basically allows or prevents either scientific expert testimony, or let me back up, either scientific evidence or expert testimony from being admitted into court. Why do we have a standard for it? Well, the Stephen Avery trial in Wisconsin gives a good example as to why. If you just throw any old test at the jury, you leave the jury to try to figure out whether the science is sound, and most juries are not made up of scientists. So the federal courts have this standard that's named after a case. It's the Daubert case. That standard basically sets a threshold for the introduction of scientific evidence into court. We need to have standards like this so that the science doesn't go all willy-nilly, and so that our courts aren't making decisions based on junk science, pseudoscience, or anything like that. Well, the candidate sitting there knew nothing about it whatsoever.
Right. I mean, our viewers all know what a motion limine is. Our viewers all know what the Daubert standard is. If you watch any, yeah.
And in case they don't, look, motions in limine are those motions usually, or I should say almost always, done before trial to ferret out or weed out evidence. Attorneys are always filing motions in limine. It's like one of the most basic things attorneys do. I'm filing this motion, Your Honor, because I absolutely want this piece of evidence into my case, or I am filing this motion in limine because I absolutely do not want this piece of evidence in my case. And a lot of times here on Law and Crime, we're sitting there around that table talking about what's in these motions. You know, hey, look, they've got this testimony from the child in the Adam Matos case. Is it going to get into court, or is it not reliable enough? I mean, that's a great example of one of these motions, and we talked about it forever. But yeah, it's a problem when you've got a judicial candidate that can't answer a question about what that motion actually is.
Right. And if this guy, you know, his reason that he gave for not knowing, I think he said he hadn't done a deep dive, you know, into those issues, and that he's aware that this would be an issue that he would obviously have to get up to speed because, as I said, he currently serves on the Federal Election Commission, which obviously doesn't deal with trials. It's sort of an enforcement agency. So, you know, this would be an issue if this guy were actually to take a federal judgeship and be doing trials in a courtroom, in a federal courtroom on a day-to-day basis. I mean, are you familiar with sort of any precedent like this, appointing a judge to a judgeship that literally has no experience?
I can't think of one off the top of my head. And look, you know, we know that the president has been sticking to this drain the swamp line. In this application, does that mean that he wants people who are ideologically separate from this process of rules of law being used to either put evidence in or keep evidence out? I mean, I don't know what the end game there is, because the whole point of these rules is that they've been built up over decades and in some cases centuries to ensure a process that's fair. In other words, a process that in our guts we're comfortable with the outcomes.
Right.
That's the whole point of these rules. You know, there was a trial 200 years ago where something happened and it just didn't seem fair, so then they put a rule into play, or a trial even 2 years ago. You know, this process builds up and builds up and builds up, but it's based on decades upon decades upon decades of us as a society, as a species, trying to make the process as fair as we can make it. Well, most judicial candidates are judged based on their familiarity with this process. Can they fairly, according to the rules, administer a trial? And if asked if a situation feels unfair, maybe they need to enact a new rule based on what we have on the books. But, you know, that's the usual standard that we look at these candidates through, and this just doesn't seem to follow that at all.
Yeah, and it really eviscerates his credibility if he does get the position, and litigants and attorneys that practice in his courtroom sort of see this. Think about how that is what ramification this testimony is going to have on his tenure as a judge. I mean, I don't think that bodes well for the future of his judgeship.
It probably wouldn't. I mean, the way that I would potentially see it rolling out is if confirmed and if he does take the oath and sit on the bench, my guess, based on what I've seen, is it's probably going to smell a lot like a situation with a court with a lot of pro se litigants, or in other words, people who aren't represented by counsel. It puts a strain on the law clerks, who are the professionals who sit in the judges' chambers, who help the judge research and who usually are the ones who help the judges pen the opinions. So if you have a judge who isn't up to speed on the law, and look, I've seen a few who I won't name at the state level, but it ultimately puts the burden on the clerks to do all the heavy lifting in the opinions. It also puts more burden on counsel who are trying cases in front of such judges, assuming, again, hypothetically, that they do exist, to basically educate the judge on the points of the law rather than counting on the judge to know it, make a quick decision, and move on. So It could slow the process down, it could put the burden on the clerks, it could slow down decisions. Ultimately, I think that it could function. Is it going to function like a well-oiled machine? No.
Right. I want our viewers, before we talk a little bit more about this, Aaron, I want our viewers to see the actual clip. Again, it's on lawandcrime.com. We're going to show it for you right now on the network. We'll come back and talk after it's done.
Thank you, Mr. Chairman. Welcome, gentlemen. Congratulations. You can just raise your hand on this one, if you will, to save a little time. Have any of you not tried a case to verdict in a courtroom? Mr. Pitts. Have you ever tried a jury trial?
I have not.
Civil?
No.
Criminal?
No.
Bench?
No.
State or federal court?
I have not.
Okay. Have you ever taken a deposition?
I was involved in taking depositions when I was associate at Wiley Ryan when I first came out of law school. But that was.
Have you ever? How many depositions?
I would. I'd be struggling to remember.
Less than 10.
Yes.
Less than 5.
Probably somewhere in that range.
Have you ever taken a deposition by yourself?
I believe no.
Okay. Have you ever argued a motion in state court?
I have not.
Have you ever argued a motion in federal court?
No.
When's the last time you read the federal rules of civil procedure?
The federal rules of civil procedure, I have, in my current position, I obviously don't need to stay as, invested in those on a day-to-day basis, but I do try to keep up to speed. We do have, at the Federal Election Commission, roughly 70 attorneys who work under our guidance, including a large litigation division. And as a commissioner, we oversee that litigation. We advise them on overall legal strategy, provide recommendations and edits to briefs and so forth, and meet with them about how we're going to handle.
If I could ask you this,
Sure.
I'm sorry to interrupt you, but we're only given 5 minutes for 5 of you. So
Sure.
When's the last time you read the federal rules of evidence?
The federal rules of evidence all the way through would, comprehensively would have been in law school. Obviously, I have been involved in, when I was an associate, that was something that we had to stay closely abreast of. And there have been some issues dealing with evidentiary issues that
Sure.
will cause me to examine those periodically in our oversight role at the litigation division at the Federal Election Commission.
Okay. Well, as a trial judge, you're obviously going to have witnesses.
Yes.
Can you tell me what the Dober standard is?
Senator Kennedy, I don't have that readily at my disposal, but I would be happy to take a closer look at that.
Okay.
That is not something that I've had to contend with.
Do you know what a motion in limine is?
Yes, I haven't. Again, my background is not in litigation as when I was replying to Chairman Grassley. I haven't had to, again, do a deep dive, and I understand, and I appreciate this line of questioning. I understand the challenge that would be ahead of me if I were fortunate enough to become a district court judge. I understand that that the path that many successful district court judges have taken has been a different one than I have taken. Mm-hmm. But as I mentioned in my earlier answer, I believe that the path that I have taken to be one who's been in a decision-making role on, I would guess now, somewhere between 1,500 and 2,000 enforcement matters, mm-hmm. Overseeing, I don't know how many cases in federal court the commission has been a party to during my time.
Yes, sir. I've read your resume. Just for the record, do you know what a motion in limine is?
I would probably not be able to give you a good definition right here at the table.
Do you know what the Younger abstention doctrine is?
I've heard of it, but again,
how about the Pullman abstention doctrine?
I heard.
You'll all see that a lot in federal court. Okay. Any of you blog? Okay.
No.
Any of you ever blogged in support of the Ku Klux Klan?
No, Senator.
Okay. Let the record reflect everybody said no, Mr. Chairman.
The record will show that.
Thank you, gentlemen. I wish we had more time to spend together.
There it is, folks. Welcome back to Law and Crime. What you're watching is the now viral video of the interview of Matthew Spencer Peterson, whom President Trump nominated to a federal judgeship in D.C. He currently serves on the Federal Election Commission, being grilled there by Senator John Kennedy of Louisiana about his fitness to be a district court judge, asking him many questions, really quizzing him on some pretty elementary legal stuff there. We were joined previously with Law and Crime's own Aaron Keller, who has written several stories. They're live on lawandcrime.com right now about this interaction. And there's a really great cheat sheet there for you, which will take you through all of the different elements of sort of the questioning that Mr. Peterson was asked about sort of what the Daubert standard is, what a motion in limine is, things like that. We're going to talk with Aaron in a little bit more about those pieces that he recently published. Until that time, we're also just hearing, late last night, we heard that Todd Kenhammer was found guilty of murder. Barbara Kenthammer, there he is, he's up on your screen. Jury not buying the story Mr. Kenthammer was selling to them. Of course, he says that his wife died in a freak accident when a pipe fell off of a truck coming at them, went through the windshield, and killed his wife. Again, many experts, a battle of the experts in this case up until Mr. Kenthammer took the stand himself, which many of our guests here on Law and Crime have said was really the nail in Mr. Kenthammer's coffin. So I want our viewers to see a little bit of that testimony. Let's watch and review some of the direct testimony of Todd Kenthammer and watch for some of the mistakes he might make on that stand.
I think the reporter knows how to spell it.
Todd Allen Kenthammer.
How old are you, Mr. Kenthammer?
47.
And where were you born?
La Crosse, Wisconsin.
And were you raised in La Crosse?
Yes, I was.
Have you lived here all your life?
Yes, I have.
Where'd you go to school?
I went to Logan High School, Logan Middle School.
And when did you graduate from high school?
1988.
What were the names of your parents?
Robert and Patricia Kenthammer.
And has your dad passed away?
Yes.
Is your mom still living?
Yes, she is.
Is she here in the courtroom?
She's sitting in the second row.
After high school, Well, while you were in high school, did you become employed?
Yes, I did.
Where'd you become employed?
A1 Glass Company.
And what'd you do there when you were in high school?
I started cleaning, sweeping floors, washing vehicles, stuff like that.
And what year of high school did you start working there?
I started in my freshman year, 1984.
After you graduated high school, what'd you do?
I was employed full-time by A1 Glass.
And when you were employed full-time, what were your duties?
I started as a auto glass and residential glass installer and a shop technician.
So as a auto glass and residential glass installer, tell the jury about what those duties entail.
Well, an auto glass installer, A1 Glass both does mobile and in-shop auto glass. They covered a very wide range, so I was on the road a lot, just over the day, not overnight, installing windshields mobily for people that worked or didn't want to leave their home to get their glass put in.
After you served for a while, well, let me go back. For how long did you stay at A1?
I was at A1 8 to 10 years.
And while you were there, did you always just stay on as a glass installer?
No, I eventually became an officer in the company.
And what was your office in the company? Do you remember?
I don't remember what it was, for sure. I was shop manager, and then I got an office title or a position.
Was there a time when you discussed becoming an owner of the company?
Yes.
And just very briefly, what was that about?
The owner at the time was wanting to sell out, retire, and I and another guy he was gonna be the office person, I was gonna be the shop person, and we split the duties, and that's when we became officers in the company.
And did you eventually become an owner?
I did not become an owner.
And why was that?
The owner was having an affair with one of the office girls, and it was bringing the morale down to the company, and I, being the shop end of the company, brought it to the attention, and I got terminated.
After you left A1, where'd you go next?
I went to Glass Service Center in La Crosse.
And how long were you there?
I was there 3 years the first time.
And what'd you do there?
Same duties: auto glass, storefronts, residential glass, shop glass.
And you said you were 3 years the first time. What occasioned your leaving after 3 years?
I went to I gotta think of this now. There was the dad owned the company. There was 4 brothers involved in it, and they were buying the dad out. So it was 4 bosses that were there taking the position of 1. And it was too hard to work for 4 people.
Welcome back to Law and Crime. I'm your host, Caroline Polisi, and I'm joined with Law and Crime's own very Aaron Keller here today. He's joining us via Skype. Aaron, thanks for being with us.
Yes, sorry, we lost a connection quickly, but I'm back.
You're back. You're back. That's all that matters. So we just showed our viewers the now viral clip of the Trump nominee getting grilled by the Senate Judiciary Committee. And you wrote a few articles for the website, including a cheat sheet. So our viewers just saw sort of the grilling, the questions there about sort of some, pretty elementary legal questions there. And can you take us through those questions and the correct answers, if you will?
The correct answer is yes. So we put this cheat sheet up on lawandcrime.com. My sarcastic side suggested that we should probably do this because, look, I mean, now that this thing is going viral, hopefully it's a chance for people to learn about the system, perhaps even the candidates themselves. So we called it a cheat sheet. Here's the thing. We were talking about the Daubert evidence standard. A lot of our trial watchers know about that. That's the standard that's followed in the federal courts since 1993 and also a number of state courts that basically says the key word is reliability. There has to be reliability behind scientific evidence that's used in court, and they run through a series of prongs of an analysis, or of an analysis, I should say, to indicate that we're not putting junk science into trials. One is whether or not the technique has been empirically tested. One is whether or not it's been subjected to peer review. That's a big one. Has it been published in a scientific journal? Have other scientists been able to replicate it? Do they agree with it? That's one of the things that the courts look at under this Daubert standard. And as, of course, our viewers just saw, this judicial nominee couldn't articulate what the standard even was.
Right.
And rung through the various prongs of it. I mean, if somebody put a gun to my head a couple of weeks from now and said, can you read off every single prong of it verbatim, I might be a little bit stuck, but I know what it is, and I know how to see it, and I know how to recognize it when I don't see it.
Right. Okay, so what was the next question was, I didn't know what this was, actually, the younger abstention doctrine.
Oh gosh, abstention gets into the weeds really, really far, but it's a basic principle. And basically what it is you, and this is boiling it way down to low gravy, but basically what it means is that the federal courts are not going to look at your state law case. Usually that means state law criminal case until there's a final verdict in the state courts. In other words, if you're being prosecuted for a state law crime, which is what we're covering 99 million times out of possible chances here on the network, you can't just jump up to the federal court in the middle of you being prosecuted for a state law crime. You've got to fight it in state court. And then if you think there's a constitutional issue with the way that you were prosecuted or tried, then you get to jump it up into a federal court. But it basically stands for, look, do it in state court. Then if you're convicted, if the defense doesn't work, then you can jump into federal court. There are a couple of extremely narrow windows of exception to that, but they're really, really rare, and I lay them out at least a little bit in the piece. So that's basically what the younger abstention doctrine means.
That's what I love about you, Aaron. Your attention to detail never fails. I love it. So for, again, we're getting broad strokes here on the network with Aaron, but if you go to the website, you can get an even more detailed analysis. Okay, so what about the Pullman abstention doctrine?
Okay, so this is actually a really interesting case. It comes out of Texas, and it's back when people took Pullman train cars around the country. So it's an older case, 1941, but basically what it means is that if there's an independent state law ground for examining an issue, then the federal courts are going to, if someone tries to bring the case to the federal courts, they're going to kick it back to the state courts to let the state courts have their say first. So what happened in the Pullman case is there was a state law passed, and it had a lot of really horrible racial undertones to it. So the case itself is really interesting. But what they did is they brought it to federal court and asked the federal court to declare this state law unconstitutional. The federal courts kicked it back to the state courts and said, look, you need to get your run of the mill here first before we're going to take a look at it. There are a lot more nuances to it than that, but for the basic premise, that would have been an acceptable answer in this hearing.
Okay.
That, if somebody tries to leapfrog into the federal court system on an issue that the state courts could just as easily dispatch on state law grounds, the courts prefer that. I mean, there's federalism at play here. What cases go to federal court? We have federal courts of limited jurisdiction, state courts of general jurisdiction. We're not going to decide something on constitutional grounds if the states are just going to get rid of it on their own. But if that boils it down to low gravy as well as I can.
No, it does. And Aaron, I think I'm going to nominate you for a federal judgeship on the D.C. circuit. Do you accept?
No, I don't think I would accept that. I think you have way more federal practice than I have.
No, I would not have done as well on that test. A great legal mind, everybody. That's why he's at Law&Crime. Aaron Keller, thank you for joining us today. While I have you, Aaron, I want to ask you about your reaction on the Kenthammer verdict. What do you think?
Well, we've been back and forth about this. I think that the mistake first of all, was a defendant taking the stand because he really sunk himself, okay?
Yep.
And his experts didn't help him. They hurt him as much as they helped him, or it was a wash. So from a strategy standpoint, and look, I realize that I'm Monday morning quarterbacking a situation, and normally I would hate it if somebody did it to me, because we all try to make the best decisions we can with what we have in front of us at the present. But what would that trial have looked like if the defendant didn't call his own experts and didn't decide to take the stand himself? If that had happened, I think we would probably be sitting here wondering if the state's case was strong enough for a conviction.
Yep.
That might have been enough for reasonable doubt. It might not have. I know a number of our viewers were convinced of guilt from the get-go. And perhaps we would still be there. But one has to wonder what conversations were had between the defense attorney, who's extremely experienced in Wisconsin, has a very good reputation, and the client. We won't ever know that. Did the defense attorney tell the client, hey, look, you really shouldn't testify? And the client said, no, I'm going to. It's my right. Well, if that's the case, then the client does get a chance to get up on the stand because it's the client's decision, not the attorney's. And that may be a decision that Todd Kenhammer will regret.
Right. Aaron Keller, as always, thank you for joining us here on the network today. Get back to work. We expect some more articles from you posting later today on the website.
All right, I'll see you later,
Thank
Caroline.
you, Aaron. Just as Aaron alluded to, I'm going to take you back now to the direct testimony of Todd Kenhammer. Many of our analysts are saying that this was really the nail in the coffin for Mr. Kenhammer's defense. Take a look.